Good afternoon, everybody, and welcome to the Aging Committee Group for Community Board 8. I'd like to welcome Julie Reyes, our chair, Artie is our community coordinator, and Farah Rubin as our district manager. Okay, so I'm just going to take the roll call. Mary Ellen Gibbs, chair, that's me, I'm here. And Barbara Kale?
Right here.
Okay, you're here. Georgia Santiago?
I'm here.
All right, so we do have quorum for this meeting. And now we'll just quickly get the business stuff out. We have the approval of the minutes of October 10, 2024. So we'll take a vote. Does anybody oppose? Anybody oppose the minutes? Barbara, Georgia?
No, I don't.
Okay, anybody abstaining?
I have to abstain.
Oh, no, you're not. Oh, you can't vote. You're in that committee. Yeah.
Okay, fine.
Anybody abstaining? No, and all in favor? In favor, Barbara? Georgia, in favor?
Yeah.
All righty. Thank you, ladies. That takes care of that. My chairperson's report. Last month, we were at the Hebrew Home. David Pomerantz, the new CEO of the Hebrew Home River Spring Living, he was our speaker. Very informative. He gave a lot of good information about nursing homes and budgets on everything, and it was a good time. Yesterday, I attended the Mayor's Round Table. It was very informative. It was people from all over the city came to speak and tell the mayor what older adults need, which we need a lot of funding for our nursing homes. We need funding for our oh my goodness, I'm having my senior moment. Senior centers, thank you, Farah. When you have a good district manager, they keep our seniors in line. So yes, there's a lot of budgetary things that I mentioned, especially like SCREE. I brought up the SCREE problem. Whenever the rents are so high and all the bills that you have,
Right.
to raise, I wanted them to see we can raise the requirement. You can only make $50,000, and in these days, $50,000 is nothing to pay your bills, and seniors, everything up. So, I also did an article last week on elder fraud.
Oh.
I enjoyed doing that because, you know what, I think I want to kind of do a series on that because there's way too much elder fraud. They're sending emails and everything to seniors saying, well, if you put this check into your bank, and you want to put it in, and all of a sudden all your money disappears. They call you and ask you for different things or your Medicare number, and it's a real problem. Older adults are really getting ripped off these days, and we can't afford to be ripped off. So we have to really put that out there in the community so we won't be so vulnerable. And that's the end of my chair's report. So now is the best time. We're going to introduce, we have Teresa Grant Stoltz. She's an attorney, and she's going to be speaking to us on wills, trusts, estates, and elder law for older adults. So at this time, I'm going to turn it over to Ms. Teresa.
Okay. So I'm certainly happy to be here. I'm so glad I was invited to come and to speak. I practice in the Riverdale, Kingsbridge area, down in Inwood too, have for a number of years. In fact, I'm kind of getting to the retirement stage. But I've been speaking at community groups in the area for many years, so it's a real pleasure to be here. So my job today, and you're certainly looking at a lot of different aspects of what seniors face all the time, what I'll be dealing with basically is kind of getting legal matters in order so that things are ready for that time when you pass on. Generally, I describe it that people have a goal, what they would like to happen when they die, where they want their things to go, and who should be in charge. And you try and put everything in order so that that happens. Well, that's what I'm here to do. There are many, many paths to that goal of having things in order. And that's what we will kind of, basically talk about today. I have some handouts, so when you guys come in, or maybe they'll get miraculously sent to you through the computer, that'd be great. I will, I'll leave a bunch of them in the office, because some of them are forms too, which might be helpful. So basically, when you think of your legal paperwork that you want to do to take care of estates, you think of a last will and testament, you think of power of attorney, healthcare proxy, living will, and trust. So that word trust, that means so much and has so much depth to it, because there's so many different types of trust. I'll deal with that in a little bit. And by the way, if there's questions, we're a nice small group, so just chime right in. I think it makes it more interesting that way. Okay, I'm going to start off with power of attorney. I'm going to start off with last will and testament, only because that's what people think kind of as the culmination of that document that you prepare for your death. A last will and testament becomes effective at death. And it basically says that this is what should happen to my worldly belongings, whether it be bank accounts, cash in the drawer, the lottery ticket that you just bought and before the truck gets you, whatever, that you get to determine what happens. You might leave everything you have to the dog and cat hospital. You might leave everything you have to your spouse, but if your spouse dies, then you can say, well, then my kids get it and my grandkids. There's a lot of ifs and if this happens, then that you can do in a will. You can explain a lot. You might also find it necessary, especially you guys with children and stuff, if they make wills, which maybe they should, and they have little children, little child can't take care of money, you can set up a trust in a will to take care of a child until they're a certain age. So there's lots of leeway in wills. You also get to appoint your executor. That is the person you want to be in charge. You might have 3 or 4 kids, 5 kids, whatever. You might have lots of friends, but you know that there's one who's really good at this, so you want to put them in charge. It also is something you probably want to tell them you're doing so that they can be aware and then kind of know some ins and outs, which we'll get to in a few moments of what those ins and outs are. So a last will and testament is something that is generally drawn up by an attorney, and it has to be done in such a way, it has to be witnessed by 2 people. There's no notary involved. The notary is for the witnesses, but not for the person who's signing the will. Different states require 3 witnesses. New York only has 2. There are certain requirements that the witness has to be present when you're signing, that both witnesses have to be together, and they both have to observe that you signed the will. In their opinion, you have to be of sound mind and speak English, and everybody kind of knows what's going on. The witnesses don't have to know what's in the will. It's really none of their business. But they do have to know that this document that they're being asked to witness is signed by you, and you're saying, this is my will. That's all they need to know. There's a certain formality in doing a will, so that's why I say it really should be done by an attorney. A will becomes effective when you die. You can change it right up until you die. You can make any, tweaks and changes and whatever else you want to do to a will. All right, so that's one thing. Oh, and one other important thing about a will that people don't realize. The will controls assets. An asset, again, can be anything from a bank account to cash in your drawer to your furniture in your apartment to the Rembrandt you have on the wall. It only controls items that are in your name alone. Now, what do I mean? If the furniture's not in your name alone, yeah, but it's yours. It doesn't have any liens on it by anybody else. Maybe the Rembrandt does, but thank you. The idea with being in your name alone, if you have a bank account and you have a joint owner, that joint owner gets everything in that bank account, regardless of what your will says. You might leave everything in your will to the dog and cat hospital, but if you have a joint owner, your neighbor or your daughter or whatever, on a bank account, that's who gets that bank account. Same thing with an insurance policy. You have a beneficiary. So it's really good and it's fast. If you have kind of a simple estate, maybe 2 kids, put them on everything you have as a beneficiary. Like, it's kind of a no-brainer. It's just easy. You can even have your spouse and yourself hold something jointly and still hold it in trust. Stock accounts also, you can do that too. And there it's not called in trust for, like a bank account is. We know what that, we've seen that on our bank accounts. On a stock account, they call it transfer on death, TOD. A savings bond, if you have any of those anymore. That was always big, but you don't hear much about them anymore. Transfer, that is a POD, payable on death. So there's just different names for different kinds of accounts. Also, one thing, I'm going to point out my gems. One of my gems is here. If you have a retirement account, IRA, 401k, stuff like that, you definitely want to put beneficiaries on that account. And do not let anybody tell you that it's okay to just put your estate. By putting your estate, it means it goes through your will. Wills, first of all, take a long time because they have to go through probate. Even with a simple will these days, the Bronx, they're not fast anymore. COVID kind of put gumming in the works. Everything takes forever now. So if you can avoid probate, you probably want to. But by putting beneficiaries on things, especially on IRAs and 401ks and TDAs and stuff, if you do not have a named beneficiary on that account will be liquidated, and that should automatically in your mind trigger something, because you know what liquidation means. It means it's going to be taxed, because that money has never been taxed. It'll be taxed, and your estate will pay the tax, because that's where it's being liquidated into. The estate has a higher level of tax than individuals, plus your kids or whomever you want to get those items, your nieces and nephews or whatever, they're going to get that much less, because at least now most people get 5 years to liquidate an IRA if they're a beneficiary. Sometimes it's 10 years, depending upon the rules that they fall into and when you created it and stuff. But you just want to make sure that on those accounts that there's a beneficiary. That's one of my gems. The other gem I referred to a few minutes ago, and I'm going to go back and forth with this one, because it's a matter of when you make your will, what do you do with it, right? You put it someplace where people will know where it is, right? Try not to hide it too well. Don't keep it in a safe deposit box, because safe deposit box is kind of a rigmarole when the bank knows that a person is deceased. Even if that person has access to your box, it's just not a good idea, and there's really no reason to keep it in the safe deposit box. Keep it in your house in a safe place, whether that's the hat box in the closet, whether it's in the file cabinet drawer under W or Doomsday. I have a Doomsday file in my house for my kids, so we laugh over it. But it's a list of what they should know in case I go quickly, and my husband and me. It's why it's a fun thing to just put aside. We don't have to think about it at the moment. But it's a good idea to leave breadcrumbs. So that's my second gem for the day. Breadcrumbs. Let people know, especially the executor, the person you want to be in charge. Let them know, and let them know where stuff is. Your tax returns are really important, if you file taxes. But if you do, tax returns are like the Rosetta Stone of your assets. It got all this great information. It has the list of bank accounts, so that sometimes we don't get statements these days, right? And speaking of which, when we don't get statements, that means we're probably dealing with them online. So if you do have accounts online, does anybody have your passwords that you trust? I will just throw that out there to try and, we're all supposed to have different passwords, and sometimes we let our computer remember them and stuff. Get advice on this. If you have a kid or a grandkid and they're good at this, talk to them about how to do this in the best way possible. You certainly want to protect your assets, and that had to do with, because seniors are so out there and ready to be, preyed upon. So you want to keep things safe, but you also want to let the kids or whomever you really do trust have access. So figure that out on how you can do that. Some people actually just have it written down on a sheet and they hide the sheet somewhere. Yeah, you can kind of write in code too, But again, let your executor know, right? And your executor is probably a relative, so that's good. Right? Could also have a secondary executor in a will if the first one can't do it, maybe even a tertiary one, just in case. It's a good idea. You don't have to keep running to redo the will every moment then. Yeah.
So the executor can be, say, a spouse or a
Oh,
child?
absolutely. Yes, in fact, it really should be. I hate going outside the family unless you have to. Yeah. There's a fee involved with being an executor too, you know, and that's okay if, you know, it's a complicated estate for some reason and there's a lot of work to be done. But if it's just one of the kids, you know, it's just a matter of you're picking one to do it so that the other ones don't have to, right? You also want the kid who's kind of the leader of the pack, if possible, the one who kind of will figure out a fair way to manage things. How do you divide things up in the house? You know, you don't have to necessarily have a list, although you could. That's always a fun thing to do. I've been more recently saying to people that if they can't decide who gets what, just sort of say, I give everything to my executor and let her figure it out in a fair manner, you know. And if you don't think you can live with that, then figure out another way of doing it. But this way you don't have to do this, that, and the other thing. You can have a list on the side, though, to help people know, oh, you know, Susie always admired that painting on the wall, so I want her to have that, and Janie can have the Wedgwood and, you know, the leek or whatever the other fancy things are. And the Rembrandt, maybe that should be sold. So you can kind of have to think about all that. All right. That's the will. We'll come back to the will. The other documents I want to mention to you for the moment are documents that are important while you're alive. We got a power of attorney, healthcare proxy, and a living will. So there's a demarcation then between the last will and testament and the other three documents. Power of attorney, a legal document set up by the New York State Legislature on exactly what you need to do if you want to appoint an agent who can act for you while you're alive. You die, your power of attorney dies with you. Your agent has no more authority if you're not there to be the person that they're representing. Makes sense. There's a new form for power of attorney, so if you have an old one, banks have to take it, but it gets worse and worse as you walk in, you know, they're, don't come in, you know, the banks like to say no right away, so maybe it's time to review your paperwork, get an updated one. I do suggest you go to an elder law attorney who will have extra powers listed just in case there are issues like you might need home care and you want to have the person be able to hire people to take care of you. And again, your money should be used to take care of you if possible, so you know, if you have any. And as we know, when you run down to a certain level, you might be eligible for Medicaid. And that might be home care, or it might be care in a nursing home. Okay? But power of attorney is really an essential document, and I recommend everybody has one. You can no longer go to the bank and have them fill it out. They will not do it. You really have to get it from an attorney, would be my suggestion, not at Staples, just because it gets complicated, so.
So when did the new form come in?
In 2020.
She's gonna hold a little question, so after the presentation, then we'll call on you.
Okay.
Thanks.
Yeah, I don't mind.
No, it's just.
Okay, 2020, the new one came, and before that, I think it was like 2010. So they re-up it every once in a while. And somehow in the middle of COVID, the state legislature managed to do a new power of attorney. It was great. A power of attorney has to be notarized, also has to be witnessed by two people. So, and these are obviously people that are not being the ones appointed in the will. So, okay. Now, the next one is healthcare proxy. It used to be that your power of attorney, the person that you appointed as your agent under the power of attorney form, could make medical decisions. Well, that was severed also in the late 90s, and a healthcare proxy came up in New York. Other states call it a medical power of attorney or other such documents. Again, these are state-run documents. So if you decide you're going to go to Florida and live there, you probably want to get somebody to look at the documents you have to see if you might need to re-up according to the law of the state that you've moved to. New York is very comprehensive, But again, you know, there were different kinds of banks in different states and stuff, and they might have different requirements. So it's a good idea to just have things looked at and to check your legal papers every 5 years or so to make sure that nothing has changed. Oh, I didn't know I put that in. Let me get rid of him, you know, in the will. I don't even see him anymore, whatever. Oh, and another thing the will does, by the way, is if you leave to a person, you can say, and if that person is deceased, then their children get it. They don't have to unless, you know, you say that. Grandchildren would automatically, but, you know, nephews and nieces and maybe the neighbor, but the kids are also very nice to you. You'd like them to get it. You can say things like that. Remember, the will is where you have a lot of explaining to do and can do. Whereas on a bank account, you could have your name in trust for. You can just put their names. You can't say, and if one is deceased, the other gets that. It's all by banking law, but you can at least name people, which is a good thing. All right, so a healthcare proxy. The other thing about a healthcare proxy is, again, it's witnessed by two people, and it comes in various forms. The one that I'm going to leave here is a one-page document. And I like it because, especially when it first came out, the faxing was a big thing. Now everything is scanned. But once it gets to 2 pages, you know, the second page would become lost and the first page appeared and who signed this, who does this belong to? So I always liked it on the first page. You get to appoint a primary agent as your proxy and a secondary. Another important thing, here's another gem. When you do your healthcare proxy, remember, please put not only the address, because that's suggested on the form, but the telephone number of the person. All right, this is going to be a doctor, either in an emergency room or in somewhat of a quick situation where a decision needs to be made. Something has come up in the middle of the night and you're in the hospital. The doctor needs to get on the phone. And I whenever I'm with groups like this, like, I cannot tell you the number of times that clients will come in, oh, I have a healthcare proxy, here it is, you know, and it says my son George and my daughter Harriet, and it just gives their address. And I said, okay, just let's imagine now, you're in the emergency room, and the doctor said, okay, so is George George Mason here, you know? No, he's not, he lives in Connecticut. So you have to put the telephone numbers, plus make sure they're updated. These days, we have our portable numbers. In the old days, when you changed your cell phone company, you had to change your number, and if you remember those days, oh, goodness. Now, at least, you keep your telephone number, and that's important. But healthcare proxies are really essential. You should have extra ones when you go to the doctor for your regular yearly visit, or you go in for a procedure or something. You bring the proxy with you. They will scan it into the system, and then it's there, and that's great, so that you don't have to worry. I also recommend that you carry with you, this is my third gem for the night or the afternoon, have in your wallet some kind of information as to who should be called in an emergency. And you say, well, I have my phone. They can't get in your phone, right? All right, there's an ICE number in case of emergency, but just in case, what if the phone has fallen off the bridge with you and it's floating down? It can't turn it on. Just imagine that you are there, you have your wallet in your pocket, and you have all your cards in there, your Medicare cards and your supplemental card and all that. So the EMS will look for that. They will also look for somebody to call. So give it to them, all right? Leave the breadcrumbs, because they're important, all right? So I used to give my cards out to people and say, just on the back of it, put this is my daughter so-and-so, this is her phone number, she can't get her, call my granddaughter. Perfect. And I cannot tell you how many times I have received a telephone call from a doctor in an emergency room because someone was brought in and in their wallet was my card. And I have a file for them, and in it was a healthcare proxy. And I was able to fax it to the emergency room, and they got in touch with the son. So, you know, if you leave your breadcrumbs, that's great. So even if you just have something, and then they follow them, and they'll find the next thing. But you want to make a plan so that things are easy, and the result is what you're trying to set up. So that's the name of my game today, is to try and get to the goal so that things happen the way you want, but you've got to do some things to get there. All right. Let's see. The other thing about healthcare proxy, one more thing. On the form itself, there is a number 4. It's listed. Name, the appointment, the secondary appointment, how long is it in existence, and any things you want to add to the proxy. Under the law in New York State, the proxy has the ability to make medical decisions. What's medical? Should there be surgery? Should there be antibiotics? Should there be this kind of procedure or that kind of procedure? You know, whatever the doctor is saying should be needed medically. But regarding tube feeding and artificial hydration, because this was made in the 90s, and I don't know, the medical, hopefully they're smarter now, I think they are, but in those days they thought that because humans like to eat and drink, you know, water and sustenance, that's not a medical decision, that's just survival. So the assumption was that the proxy did not need to interfere with that. So if you want your proxy to have the ability to say, don't put a tube feeding thing in, whatever, don't hook up a tube feeding device, or don't give the artificial hydration, you know, because death is imminent. The hospital will always do that unless you give the power to your proxy to say no. So it's really important to remember that. In the proxy that I hand out, and I'll have here, it just says, my proxy knows my wishes about all decisions, including artificial hydration and tube feeding, and should be the party to make those decisions. It might very well mean that they say yes. You know, as I always say, if you're choking on a chicken bone, oh yeah, please do the Heimlich, thank you, I'd appreciate that, you know, let's not be silly. So, but let the proxy, because this is a person that you're trusting with those very, very personal decisions and important decisions. All right? So let the proxy make those decisions, not some hospital board or a doctor that you don't know necessarily. Okay? All right, so remember, if you have any questions on that, to write down. I didn't know I couldn't take questions.
I have to write mine down.
Okay. All right, that's good. So I think everything is stated on that. And I have a little outline here of what I'm talking about so I don't forget things, and it has those little pieces. All right, the living will. Now, the living will is something people hear about, and it is very much misunderstood. First of all, the living will, unfortunately, is named a will. It has nothing to do with the last will and testament. It's just, unfortunately, it's like, you know, the will is what the person wants or whatever. But it is not it's not really even a legal document. A living will is your preference. And by signing a living will, and there's no set format for a living will, by signing a living will, you're merely saying that you basically do not want to live under certain circumstances. You're helping your proxy so that they know what you may or may not want. So you might say, if I have a terminal condition and there's no reasonable expectation of recovery, just don't keep me alive for the sake of it. Let nature take its course. And by not prolonging, it might mean anything from, again, surgery to intravenous, any kind of activity the doctor might think appropriate, right? But if your time is up, you can say, and this again depends upon your stage in life too, you are just helping the person that you have appointed as proxy to know what your wishes are. And again, I have to speak from my own experience with families who have said to me, it was so helpful that Dad signed the living will, because then we knew, and we felt it wasn't our decision to like not do anything. The doctors were all saying there was no hope, but you never know. So it was so helpful to have my dad having signed that, or my mom, or my grandma, whatever. But it really matters if you are of that opinion. And I've had clients, and totally they're within their right. Hey, if there's a chance, keep me going. You never know what might happen, and that's fine, right? But in my experience, most people do not want that. But that's, again, a personal decision. All right, so Okay, yeah, and the most important thing to me about having a living will is it helps your loved ones know what your wishes are, so it kind of takes the onus off of them. They feel like they're not the ones deciding. Okay, so those are my 4 documents, and I threw in trusts as another one. Now, you've heard of trusts. Trusts aren't for everybody. The old joke was, what's the difference between trusts and wills? And the thing went something like, if you live in Florida, you have a trust, but if you live in New York, you have wills. And that's not really accurate, of course, but it's a good joke. But because wills are basically always needed. And here's why. Because a will, as I look at it, or I want you to think about it as, is the safety net under which all of your decisions, those kind of boxes that I was telling you to leave breadcrumbs and leave decisions and things so that people know what to do. If anything falls through, well, at least the will is there to still control. And what am I talking about? Well, if I put names on bank accounts and I have my beneficiaries all set, and on my IRAs I have my kids and my grandkids and all that, what could possibly be the problem? Well, your Aunt Tilly, who you forgot about because she lived in Canada, and in fact you weren't even sure if she was still alive, but she didn't forget about you. Guess what? You're in her will. And you come into an inheritance and you didn't even know. Or the guy down the street who you always did groceries for, he died and he left you money and you didn't expect it. Those are things that would go, if you're deceased also, would go to your estate. If you're alive, no problem. But if they would go to your estate, hey, if you don't have a will, guess what? Those items are in your name alone. So, you know, the other thing is also, let's say it's a beautiful day, kind of like today, a little cold, and you go out and buy a lotto ticket, right? You think, oh, I just feel great. I'm going to have that lotto ticket. And you're walking down the street and you're thinking of all the things that you're going to do when you win, right? And unfortunately, you didn't notice that there was a truck that was a bit out of control coming down the street. And, well, the good news is that your lotto ticket is a winner. The bad news is the truck got you. So you have two things coming to your estate, right? One is the lotto ticket or anything you didn't realize had a value. It could be the baseball cards you've been, you know, protecting or keeping, whatever. But there's a lawsuit, believe it or not, that your estate would have against the fellow who lost control because he didn't get the brakes. He left the gas station before they fixed the brakes, and he knew it, and he works for a big company, and there's a lot of money there for your estate and your people. So, it's kind of a silly and hopefully humorous way of expressing the fact that you always have a will because you never know what might come into your estate after you die that you then honestly can't enjoy, but the people that you want to take care of, they can enjoy it. So wills are always important. So even if you have trusts, a will should be there also. Now, what do you want to have a trust for? Well, I mentioned before, if you have kids, right? You don't want to leave, you don't want to die and have the money go into your kids' pockets, even if they're 12 and 15, right? It's a little young, even though they're not 2 and 3, or grandkids. So a trust can set up a fund. Basically, a trust is a set of papers that sets up an empty vessel into which something will be put, goods, some kind of assets. They'll be held there by the trustee for a period of time to be used in the future. So the trustee is the person who you appoint in the trust to take care of things. They will take care of whatever, they will follow the instructions that you have set up in the trust, that the money can be used for the education and health needs for the youngsters until they're maybe age 25, because you usually want to get beyond when they're out of college if they go to college. But you might also say, but if they don't go to college and they need a down payment for the house, yeah, let's use it. Or, just as long as it's not for the Ferrari, but if whatever else they may want to use it for. You can put all sorts of little provisos in there, and you want to give some discretion also to the trustee in a trust. What else would you want to do a trust for? Common misconception is that you can avoid, huge amounts of taxes. You can, and in various circumstances, but generally, unless you have a lot of money, a trust is not going to help you with taxes, but it helps you with other things. You can slice and dice trusts in whatever way you want. The two slicings I've just done already, one is a testamentary trust created in your last will and testament. A living will is created while you're alive, right? You may decide, I'm going to put money aside for the grandkids now, and I'm going to set up a trust and put money in there so that there's money put aside for them to go to college or do whatever has to be done. That'll be a living trust. You might also say, I'm creating a trust because I don't have any relatives, and I have a lot of people I want to take care of, and if there's any money left after, if I don't need to use it, I would like to not have to worry about probate. Probate becomes very complicated when there is when there are no relatives, because you have to kind of look for them. Especially, I have had a lot of clients who lost people in World War II in the Holocaust. Very hard to piece all that together. So it just takes time and money, because you have to get some kind of a person who does hereditary, and unless the gentleman on TV, Gates, who does that, but he only does it for famous people. So if you can avoid that, that's one other reason for doing a living trust. Put everything you have into a trust, and then the trust will live on after you die. When you die, that's the trigger in the trust. That means your co-trustee or your successor trustee will then take over and deliver the money out where it should go. Maybe pay your funeral, do whatever else has to be done. And it's precisely for that kind of a situation that if you have a living trust and you think you've put all your assets in, so I don't need a will, you can go back to my discussion before about why the will is under there just in case, because you always want a will just as a backup. That, by the way, the backup will can be called a pour-over will. That is, anything that kind of fell into the abyss because you didn't know you had it while you were alive can just be poured into the trust and be distributed the way the trust wanted. So again, another way of talking about why trusts might be important. And the next one I'm going to bring up, because when I have spoken to seniors, this is the one that comes up mostly: an irrevocable trust. One that cannot be revoked. And you say, well, why would I ever want to do that? Because it would be giving your money away, usually to kids, right? But it's held in trust for your lifetime to be distributed to the kids when you die, in order that that is not an asset in your pocket. And why? Because we know that what you're concerned about is if you ever got sick and had to go into long-term care, it's very expensive. $18,000 a month, most people, that's not going to last for that long. And, all the money that they have saved and hoped their kids and grandkids would get is not going to be there. So if you want to, you could set up a irrevocable trust, and into that put assets that you're not going to need, right? Last thing you want to do is put all your stuff in an irrevocable trust, and then it's like, hello, oldest daughter, I'm thinking of going out for dinner on Friday. Can I have some money? None of that, right? You keep out enough, obviously, that you can have a independent life and maybe have some nice vacations and things. So the most obvious thing to put into an irrevocable trust is a house, right? If you live in a house, and even if the house eventually gets sold, who would sell it? You don't own it anymore. You've transferred it over to the trustees who now own the house. They would sell it. And, so it's like you're not losing it, but you want to make sure that you trust whomever you put in charge. Most of the time it's kids, and then they will take care of each other, their siblings, and hold assets until you die in that trust. There's also a way that if they needed money, they are allowed to take money from the trust, and that is into a whole nother conversation. But so at this point, I usually ask for questions.
Okay, so questions go to committee first. If any of the committee members would like to ask a question. Barbara, Georgia?
Yes, I would like to ask, if you would mind repeating that, understood it to say P.O.B.?
POD,
Take a note,
payable on
but-
death. And so payable on death would be a designation on a savings bond. And usually it says it right on the savings bond. So owner would be, and then POD, payable on death. And
Oh,
then
I
on
had
the-
D. I'm sorry.
There you go. That's all right, and thank you for
Thank
clarifying that. And then the other example I used was TOD is on a stock account. Your name, TOD, is transfer on death, only because, again, it's in different laws that have the different terminology. That's all it is. And at bank accounts, it's your name in trust for. And it just means that there's no trust involved. There's another use of a term that has nothing to do with setting up a trust. It just means you're holding it for that. All of those are you can change them, by the way.
Thank you.
All of those while you're alive. So, yeah.
I have a question.
Julie, Barbara?
I'm not sure. The host of the Zoom has disabled my video. I'd like
Yeah,
people
we're
to
gonna
see me.
put it back on.
There
Okay,
you
Welcome
are.
back.
Hey.
I'm sorry. I had to take a call. I didn't quite know how to do it quickly. No, it makes a lot of sense to me. I've had some experience. I have set up a very elaborate will with a family trust and then another trust that's outside the estate. Don't
Okay.
ask what it cost.
That's
Just
okay, but as long as you understand it and your questions are answered, that's good, okay?
It's very important. I can't stress enough. Do it ahead of time.
Excellent. Good. And again, you've made plans now to get to the goal that you want to do. And there's, again, many ways of getting there, but trusts are a good way of doing that. And congrats. So, good.
Yeah.
Julie Reyes.
Hi, I just want to say thank you so much for this great information. My question is, you mentioned in the living will about do not resuscitate to put it in there. Is it advisable to also put it in the health care proxy, or are the two documents attached at the hospital?
They shouldn't be, and this is a good question, and I didn't hammer this out. The healthcare proxy is the legal document, and basically the most important thing it does is empower a person that you want to be the person the doctor talks to make decisions, and if the doctor cannot reach the first person, they'll call the second. And in fact, I have an attorney colleague who says she puts the third on too, if people, want that. And the doctor probably won't go through 5 names, but probably would go through 3. You imagine it's kind of a tight situation, so you can't be too demanding. Okay, now your question was, I went off on that.
With the DNA, because if the if the person shows up with the
right.
healthcare proxy, does it have to be
Okay.
stipulated in there?
No. The healthcare proxy would have the ability to make a decision on what should happen to you in talking with the doctor. But I have to say, and I'm glad you brought up about a DNR, which is a do not resuscitate. And what's left off at the end of that is it is an order. It's a DNR order. It is actually an order signed by a doctor. And usually, obviously, it's done in a hospital so that they will not call a code on a person who has signed a DNR or whose family has signed a DNR on their behalf. Or maybe the person's in a nursing home, or maybe the person is home on hospice care. Those are situations where normally it is thought to have a DNR in place. Most people who are up and walking around who don't have something within them that they know that they are going to die based on it, most people would not have a do not resuscitate order because it could be something that can be fixed easily. A DNR is something that really you know, I mean, it normally applies to somebody who is terminally ill, suffering from that terminal illness, and it's going to get them. It's just a matter of when. So, you know, like it's not to prolong your life. If you have a DNR on you, then your proxy doesn't have to make that decision. But if you have a situation where you become ill and are unable to talk with the doctor, your proxy could make the decision for you with the doctor, because you kind of want the proxy to talk with the doctor and see what the doctor says in terms of what your prognosis is and all. The doctor, you know, might say there is really no hope after this accident or because of this illness. And it's going to be rather painful, so we'll do a lot of medicating. In a case like that, I would think you would want the proxy to sign a DNR with, actually, the proxy doesn't sign it, the doctor signs it, but with the approval or at the direction of the proxy. Does that make sense?
Yes, thank you, because I have a family member who ended up in the hospital and wanted the DNR, but other family members did not. So that's why I want to make.
Oh, that is so familiar, yeah.
So if it's in a healthcare proxy has the healthcare proxy and the doctor really have the last word then.
They really do. They really do. And that's why, you know, among your family, you want to pick the one member. Usually people go with the person who's has any kind of medical training, whether it's a nurse, doctor, dentist, you know, just somebody who has some kind of medical background. But it also might be the person who thinks most like yourself, you know. It's a toughie, and I have seen it where families are in disagreement. It's very tough, very tough.
Okay, great. Thank you so much.
Sure. Oh.
Marty, do you have any questions?
No, I appreciate the presentation and I've taken notes, but I don't have a question.
There'll be a test. Good. Oh, and the proxy, by the way, again, if you're taking care of somebody who's very ill in your house, you want the proxy readily visible. New York City, all the doors are metal, so get a magnet, stick it right on the back of the front door. That's the best place. You know why? That's where EMS will look for it. They'll also go to the refrigerator, right on the front of the refrigerator or the side. They'll even look on the side, just so it can be found, so they're not rummaging through papers. And if there is a doctor's DNR, please have that with the proxy visible, because if EMS is called, and by the way, EMS is always called in an emergency, you must tell them, because otherwise they do what EMS does, and that is resuscitate. They always will. That's what their job is. Okay.
Sarah?
I have a couple of questions.
Sure.
For a will, last will and testament, say you created a will, you had two people witness it. Does that have to be done through a lawyer, or what, would it be valid if you have a will that you had two people?
Very good, yep. A will, if it's witnessed by two people, then yes. The issue is, though, if you die in the Bronx, or you live in the Bronx, and that's where your probate is, when a will is not witnessed or prepared by an attorney, the witnesses must go to court. So if they are wayward people that you met in the hospital and you have no idea where they live, they should put their address down, but it was 6 years ago and they've moved and you can't find them, that's a problem.
The witnesses can be relatives, or?
They can be relatives, but they are not able to be beneficiaries.
I see.
If they are beneficiaries, totally invalid for obvious reasons. You know, they had the gun at your head, right? Yeah, no. Yeah, there's always an assumption that, so.
And then as far as trust, like you say you create a trust, where do you do this, or who do you have to do that with a lawyer?
Yes,
Okay.
absolutely. It doesn't make sense to do a trust without an attorney. First of all, whenever anybody would come to me and say, I want to do a trust, my thing would be, okay, what have you heard about trust and why? Well, I saw Susie Orman. Well, most people do not need trusts. They might help, though, so I'm not saying not to. In terms of the one example I gave for the irrevocable trust to try and protect your house, it has to be done 5 years before you die. Because
Okay.
any transfers made, and not before you die, 5 years before you need Medicaid, if that's the case. Because, you know, that you can't just do a transfer and then say, well, now I'm ready for Medicaid. So there are rules, and it's very complicated. So it's not something you want to do on your own. And then you have to, a lot of people think, oh, I just made the trust, I'm all set. If you don't fund the trust, then what good is it? You have to put the assets into the trust. That means a co-op apartment. Sometimes you can't put a co-op apartment, or you have a mortgage on your co-op. And guess what? You don't have the stock and lease, which are the documents that need to be transferred because the bank is holding them as collateral. So there's a lot of things you don't know, and it's complicated. So yes, you always need to go to an attorney for a trust.
Sorry, one more question.
Oh, go ahead.
Say you, set up a trust,
Yes, you put money into it for your kids, say.
when do they have access to it?
Okay, and this would be when they're baby kids and you don't want them?
No, say they were like 18, say they were adults.
Okay, and why did you set up the trust for them?
So we didn't have to deal with probate, like
Ah,
you said.
okay. Well, they would get the money when the trust says they can, and is that when you die? Yes.
Okay.
And by the way, a trust like that, if it's just to avoid probate, but probate is not the worst thing when you only have 2 kids. It can be bad enough, I know, especially these days.
I had to deal with it, it was nuts.
All right.
Yeah.
So you can also be a trust of a revocable trust. You can be the trustee of a revocable trust.
Okay.
Why not? And then again, the reason would be, you can undo it, you can put money in, you can take money out, totally your discretion. Maybe one of your kids could be the co-trustee with you. Your spouse certainly can be co-trustee. 2 of your kids could be co-trustees, no sweat. And then in the will, it also says, and if anybody wants to resign or, you know, whatever, then out they go, and this will be the next one.
Very good.
All right.
Now we'll go to the community. Would you like to ask a question?
I'm finished.
Ellen?
Asking.
Ellen, would you like to ask a question? Ellen, are you still there? There she is. Oh,
Yeah, sorry, I
There you
had
go.
you on mute. Yeah,
Oh, go ahead.
actually, I did hear about, like a transfer upon death for the deed to a house. Is that worth having?
It is. Again, though, I would suggest that you discuss it with an attorney.
Okay,
So, this is brand new, hot off the press. So there's probably going to be, you know, some clarifications made down the road. So you can put somebody as a beneficiary. It can be changed. So it's not ironclad. So that's one thing. But what it would do is it would make clear what you want to happen to your property when you die, and it would not have to go through a will,
okay,
right?
all right, thank you.
You know, I mean, as a matter of law also, when you own property and you die, if you don't have a will that says otherwise, by operation of law, that property is transferred, supposedly right at death. Like if you have 3 kids and no husband,
Right.
those 3 kids own that property, unless you've said otherwise in a will, which it's complicated.
Yeah,
But anyway, you can put it in, and it's not the worst thing, brand new in New York, brand
okay,
new.
well, if it's already in the will as to who should inherit the house after my death,
That's
do you
fine.
still need the transfer on death of the property, or no?
You don't, but you know the answer to this already, because then the will would have to go to probate.
Right.
And if you want to avoid the probate, it would be
Just avoid
faster
probate. Gotcha.
to do it
Okay.
with this, yeah. So that would be the real benefit, is you don't have to do the probate. And the probate is
Okay.
the process of the will going to the court, the executor being appointed. So the
Okay.
court gets a fee, and you probably need an attorney to do that. You don't have to have an attorney, but it's complicated.
Okay, thank you.
They get a fee based on how much is in the estate that is passing through the will.
Mm-hmm.
Georgia?
Yes, I would like to know, because my son had some saving bonds,
Yes.
which you haven't, you know, cashed in years. So I was just wondering, maybe I should call the name that's on there and the telephone number just to find out.
Yeah, you can.
value?
You can also Google it or make your son do it. So savings bonds stop increasing in value after a certain number of years. So if you've been holding on to them forever, they are just sitting there as if it's money in the drawer. You know, they're certainly higher than the face value, but you can go online and you can plug in the date of issue and the value on the face of it, and it will tell you what it's worth. My suggestion is, you're in November now of the year, cash some of them in now, because you'll get a 1099 form that has to go into your taxes. And if you do a big stack, you're paying a ton, so at least get some of them going this year. If they're in your son's name, have them just grab a stack. Just, it literally takes 10 minutes on the computer to just write out a thing. And then sometimes banks will do it, but I don't know anymore if they do. So you might have to do it through, you know, where to send them. I think it's Buffalo or something upstate. All right? But yes, you should get rid of them.
So
Just
they
start
are
now.
quite old.
Yeah, because they're not earning anything. Look at the stock market. Get in there.
There you go.
Not, you know, they're just not earning anymore. So obviously start with the oldest when you want to start liquidating, okay?
Well, thank you very much.
Yeah, that's a no-brainer, definitely a good thing to do, definitely.
Yeah.
Ms. Estevez, do you have any questions?
No, thank you, but it was very informative. Thank you so much.
Oh, good. You're very welcome. You're very welcome. It's my pleasure.
Yeah,
So
I
please
actually,
take care and remember, leave those breadcrumbs. What?
oh, I'm
Yeah.
sorry. I am the social worker at Riverdale Senior Services. And, sorry, I was just wondering if perhaps this is something that we could do at the center, like a presentation.
Absolutely. I'd be
in
happy to
March?
go. Yep.
Yeah, so I was speaking to the director of clinical services, and she's my direct supervisor, and we thought that this would be a very important topic about, advanced care planning and
Perfect.
having these things in place, because it's so important, as you were mentioning.
I'd be happy to do it. So if you get in touch with me, through the
Okay,
powers
yeah.
that be, I'd be happy. Okay?
All right, I'm sorry, I couldn't get your contact information. I'm not sure if it could be in the, typed out in the chat.
Well, I'll just give you my phone number right now to call me.
Okay.
That's all right?
Yeah, that's.
917,
Mm-hmm.
this is my cell phone, 917-701-3675.
3675. Okay, thank you so much.
And I'm Teresa, all right?
All right, Teresa, thanks.
I'd be happy to do it.
Good to see you, Ms. Estevez.
Okay.
Bye.
Good. Thanks, everybody.
Hey, Doyle, would you pick up
Do
some
you
of
have another
those,
question there? Georgia, you have your hand still up.
Doyle,
Georgia?
Pardon?
can you pick up some
No,
of
that was
handouts for
before
me?
when I raised my hand. She answered
Okay.
my question.
May I have a question?
You answered George's.
Yes.
Somebody's still open.
And thank you for the invite.
Oh, very welcome.
Thank you, Georgia.
You're welcome. Thank you.
Good. All right.
That's the end of your?
That's the end. I'm good.
Thank you so much.
Oh, you're so welcome.
I always love hearing, your information. It's so informative. I haven't, in the past, at other places, learned so much from you.
Good. Well, thank
And,
you.
I
Thank
really
you.
appreciate you being with us today.
So happy to do it. All right. And I'll leave you some of these forms.
Yes,
All
please,
right.
if you can, yeah.
I don't know
This
how
way
many
we
you
can-
want, but
Yeah,
we certainly.
'cause we do give handouts here.
Good.
So we
Okay.
can always copy them, right?
Yeah.
Marty, right? Yes?
Okay. Excellent. Good.
Thank you, Teresa.
You're
Yes,
very
Teresa,
welcome.
thank you so much.
Thank you. Always a pleasure.
They get back to,
Thank you,
Okay.
everyone.
Get the,
okay, let's see, there's my, all right, now, here we go. Back to my script, as they say in SAG. My members, is there any old business? Georgia, Barbara,
No, not from me. Thank you.
any new business that you'd like to see, some of the things that we could work on, or any suggestions that you'd like to? I know I want to work on the senior guide, make, new corrections and everything on that as part of our new business. Any suggestions, anybody?
I'd be happy to help with that too. if you
Oh, I
need
would
anything.
love that.
Sure.
Oh, that was
Sure.
so, thank you so much.
Sure, yeah,
Oh, thank you.
yeah, whatever we can do.
Wow, that'd be really good. Okay, then, so there's no old business that we need to attend to? New business? I would really like to, put out something every week too about elder fraud, keep everybody informed. So if you have any, information that you have that you'd like to pass on in the meeting to people on, on our meetings and stuff, because it's so important. I mean, so many people are being scammed now. It's like real, especially this time of the year, they're
Yep.
out there,
Yep. Yep.
I get a call every day. Now you're then on your Medicaid, and they're scams the way they're asking you, can we have your Medicare number, or
Right.
once they get that number, there's endless things they can do with it, so we have to stay aware. So if there's no new business and any old business, I call for, my committee, a motion to adjourn. Committee,
Yes. the
Yes.
committee
offer a
should be-
motion?
A motion.
Georgia, you second it?
Second it.
We are adjourned. Thank you so much, everybody.
Thank you so much.
Thank you.
Thank you,
Bye-bye.
lady.